Good morning, everyone. Welcome to the Judiciary Committee hearing. My name is Carl Rhodes. I'm chair of the committee. This Zoom meeting and YouTube live stream event will include the following agenda. We only have one today, 9:30. The other members of the Judiciary Committee are Vice Chair Keo Kalole, Senators Ocasio, Gabbard, Lee, Kim, and Favela. As noted, this hearing is being streamed live on YouTube. You can find links to viewing options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website, which is capital.hawaii.gov, capital.hawaii.gov, and capitals with an O. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Tuesday, February 22 at 9:25 a.m. via video conference, and a public notice will be posted on the legislature's website. For those of you who signed up to testify live today, your audio will be muted and your video disabled until it's your turn to go. And we do have a 2-minute time limit on testimony, although in many cases, members will have questions for you. So if you can hang around, that would be great. If there are temporary technical glitches while you're testifying, we may have to move on to other people, but we'll try to come back to you if we can get the technical problem worked out. And we do have your written testimony, so that has all been read by at least one person, in most cases more. First up on the agenda today is SB 2163. This is relating to negligent homicide. It makes it a Class A felony for a person to cause the death of another while operating a vehicle in a negligent manner and under the influence of an intoxicant if the person has one or more convictions for operating a vehicle under the influence of an intoxicant within the last 20 years, a suspended or revoked license, and privilege to operate a vehicle due to driving while under the influence of an intoxicant or the person is highly intoxicated. First up on SB 2163 is James Slater, a major for the Traffic Division, Honolulu Police Department. Good morning.
Good morning, Chair, Vice Chair, members of the committee. I'm Captain James Slater with the Honolulu Police Department's Traffic Division. We'd like to stand by our written testimony in support of Senate Bill 2163, available for questions.
Great, thank you. Next is Alan Komagome for the Public Defender.
Good morning. Chair Rhodes, Vice Chair Keoho Kalole, and members of the committee, Alan Komagome testifying in opposition to the bill on behalf of the Public Defender's Office. We don't disagree with the intent of this bill. Negligent homicide cases are one of the most difficult cases that come through our court system. However, we oppose this bill mainly because it creates a mandatory 20-year sentence in any and all cases where a person satisfies certain conditions, such as having a prior OVI conviction in the last 20 years of the offense, a license suspension, or driving while highly intoxicated. The 20-year window for an OVI conviction is too wide of a window, and we can see the potential for problems in certain cases. For example, a court may be faced with a case involving a fatal accident where a driver wasn't speeding or driving recklessly, but due to other factors such as poor lighting or the victim not being in a crosswalk, those factors could have contributed to the fatal accident. And in this case, if the driver had literally drank 2 beers at dinner but had an old OVI conviction, that person could be charged under this law. And we submit that a scenario such as this one may not be so egregious as to warrant a mandatory 20-year prison term. You know, the concerns laid out in this proposal won't go unaddressed if this bill isn't passed into law. Our manslaughter statute can adequately be applied to and punish repeat OVI offenders who continue to drive drunk and end up killing an innocent person, or a person that disregards a license suspension, drives and does the same, or someone who chooses to drive while highly intoxicated. Manslaughter can be applied to these situations where a person acts more than negligently and blatantly disregards the safety of others. Again, manslaughter is a Class A felony and is punishable by up to 20 years in prison and can address reckless conduct, which this bill seeks to prevent. Thank you for the opportunity to testify in this measure, and I'm available for questions if any.
Thank you very much. Next is Maui Prosecutor's Office in support. Alan Bartolome for the County of Hawaii Office of Prosecuting Attorney in support. William Hankins, Maui Police Department in support. Paul Ferreira, Chief Hawaii Police Department in support. Kirk Kindro, Chair Public Policy Committee, Mothers Against Drunk Driving in support. Tristan Manuel in support. Dara Carlin, Eric Abe, Cynthia Al, Bronston Koso, All in support. That's all the testimony we have on SB 2163. Members, any questions?
Chair, this is Jade Butai from.
Yes. Would you like to testify too?
Yeah, I apologize.
Go ahead.
Our testimony was submitted late, but we stand on our testimony in support of the intent. We just want to, recommend clarification under this offense for what is meant by the time of event, license revocation qualifications, and what constitutes previous convictions. Thank you, Chair.
Thank you very much. Members, any questions? Okay, so Director Butai, I haven't seen your testimony yet, so could you tell me in more specificity what it is that the issues you had with the bill?
Chair, if you don't mind, if you can unmute Bob Lung, he's my subject matter expert on this.
Sure.
Robert Lung. Bob?
Yes, the clarification they had wanted is involved with Section 2 on the what would constitute the Class A felony, and you had listed 3 things on it. We're not sure if all 3 things must be met or any 2 things being para A and 1 B or C, and that's what we had wanted to clarify on that.
So you want to know whether it's 1 or 1 and 2, or just 1, or it has to be 2 or more?
Yes.
Okay. Okay. Anything else?
That was about it. Thank you.
Okay. All right. Thank you. Members, any other questions? All right. If not, let's go ahead and move on to SB 2856. This relates to pretrial release, requires the court to extend the duration of a restraining order or protective order issued against a pretrial detainee if the detainee is granted a motion for pretrial release. First up on SB 2856 is Lee S. Hayakawa for the public defender. Good morning.
Good morning, Chair, Vice Chair, members of the committee. I'm Assistant Public Defender Lee Hayakawa. The Office of the Public Defender respectfully opposes SB 2856. The OPD seeks clarification on whether this measure is intended to automatically extend restraining or protective orders only when the protected person is also involved in the pretrial case for which the defendant sits in jail. This measure also raises a jurisdictional question. The OPD believes that the circuit court will have problems asserting jurisdiction over a family court restraining or protective order. And finally, the phrase "for a duration equal to the duration the pretrial detainee would have remained in custody" is virtually impossible to predict and will cause issues for the trial judges. I will otherwise stand on my written testimony, and I am available for questions. Thank you.
Great, thank you very much. Next is Shirley Kawamura for the judiciary. In opposition, Max Otani, Director of Hawai'i Department of Public Safety.
Hi, good morning, Chair, committee members. Max Otani, Director, Department of Public Safety. We would stand on a written testimony providing comments in this measure and would be available for any comments you may have. Questions you may have. Thank you.
Thank you. Next is Dara Carlin in support. Mark T. Nugent, Deputy Attorney General. I don't see him. Oh, there you are. Good morning.
Hi, Rhodes. Actually, I'm here to testify on Senate Bill 2869 regarding spousal support.
He'll be next up on the next one. My apologies. I didn't realize that there was a page break there. Okay, that's all the testimony we have on SB 2856. Members, any questions? I think I do have a question for the public defender, if you're still here, Mr. Komagomi. Oh, I'm sorry, Lee Hayakawa, I'm sorry. So I guess the part of your argument is that if a TRO or a protective order is granted by the family court, and someone is brought into circuit court on a criminal charge, the circuit court doesn't really have any jurisdiction. They can't change that protective order in any way.
That would be our position. The family court shall have exclusive original jurisdiction over any protective order issued under Chapter 586.
But the circuit court does have a similar power, though, right? It's a no contact order, yes?
Yes, that's correct. And we address that in, I guess, subsection A of our written testimony, that the circuit courts can already impose no contact orders as a term and condition of release.
Okay, and the other question I had about it, the procedure is, so the family court has a protective order out. Is that a public document? Is that something anybody can look up, or is that, and a lot of stuff in family court is not public?
To be honest, I'm not quite sure about restraining orders issued in family court, whether they're.
The real question is, can the circuit court judge, will they have a way to know whether there's a restraining order out?
You know, I assume that the way it would work is the prosecutor or the prosecuting agency would bring that to the court's attention.
Okay, so so there is a party that could bring it if they chose to.
Right.
Okay. Thank you very much. Members, any other questions? All right, if not, thank you everyone, all the testifiers, for being here. We'll move on to SB 2869 relating to spousal support. This allows obligees under an order solely for spousal support to elect to enforce the order pursuant to Chapter 652, which is the way debts are normally collected in civil suits. That in Chapter 651 and 653, if I remember correctly. So, okay, now it's Mark T. Nugent, Deputy Attorney General. Good morning.
Okay. Good morning. Thank you. Deputy Attorney General Mark Nugent, good morning to all of you. The Department of the Attorney General supports the intent of this bill, and we would stand by our written testimony. I'm available for any questions. Thank you.
Great, thank you. Next is Melody Aduha, Chair for the Health Committee of the Democratic Party of Hawaii. In support, Johnny May Perry. In support, Glenda Pinheiro. In support, and Nancy and Zeb Jones in support. That's all the testimony we have on SB 2869. Members, any questions? Okay, now let's move on. Thank you, Mr. Nugent, for being here. Next up is SB 3172 relating to public agency meetings. This provides that any electronic, audio, or visual recording of a board meeting shall be maintained as a public record. First up on SB 3172 is Cheryl Kakazu Park, Director, Office of Information Practices. Good morning.
Good morning, Senator, and the rest of the committee. I'll make it quick, just to let you know that we already have provisions to provide for either the full detailed written minutes of a meeting, or a board can choose to record the meeting and point to the places in the recording as to where they're taking significant actions, so that we don't have to look through the whole meeting. They have to create a written summary to tell us where exactly to look, and people can see for themselves what actually went on if the meeting is being recorded. This bill, however, would create a significant disincentive for the boards to record the meetings in the first place, because they're going to have to still do very detailed written minutes. So why record the meeting and provide a written summary as well as do written minutes? Looking now at the testimony that came in, and it appears that this bill might have been inspired by a problem that the neighborhood boards have been, on Oahu only, have been having with the neighborhood commission office. And it's seeking to address a problem with this bill that will actually end up creating maybe a bigger problem and a lot more costs for all state boards and other independent boards under the Sunshine Law. So I'll answer any questions that you might have for me. We did provide a suggested amendment, but I'm not sure that that's what this bill is now trying to address. So I'll just be here for questioning.
Great. Thank you very much. Thanks for being
Thank
here.
you.
Sandy Ma for Common Cause Hawaii. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. We support SB 3172. We like the recordings of all board minutes being kept, and we like written minutes also being produced for people, detailed minutes being produced for the public. We think this is a necessary measure for public transparency and accountability. Thank you for hearing this bill. I'm available to answer any questions. Thank you.
Thank you very much. Next is Arthur Buto for the Office of Planning and Sustainable Development. Good morning.
Morning, Chair, Vice Chair, members of the committee. My name is Arthur Bouton with the Office of Planning and Sustainable Development. We stand on our testimony providing comments and concerns. Thank you. I'm available for questions.
Thank you very much. Next is Winston Welsh.
Not present, Chair.
In support, Brian Black, Civil Beat Law Center for the Public Interest. In support, Douglas Miller, League of Women Voters of Hawaii. In support, Sterling Morita, Hawaii Chapter Society of Professional Journalists. In support, 1, 2, 3, 4, 5, 6 individuals all in support. That's all the testimony we have on SB 3172. Members, any questions? Just double check here. Okay, good. For Ms. Kakazu Park.
Hi.
Thank you for sticking around. I guess the question is, if we went ahead with provisions that said the board had to have the written minutes, but then we said you don't have to do since you have the written minutes, if you just keep the recording, but you don't have to do the written summary of the recording, does that make life easier for boards? Get rid of the disincentive you're talking about?
Well, first of all, if you looked at Mary Alice's testimony, she brings up some real practical points because not all boards record their meetings for the purpose of having it online. You know, some of them just take like, what do you call it? Audio tapes of them so that they can go back and prepare the minutes. And she says some people, they have multiple staff recording it with all kinds of different
I understand. I understand that point. The question I had was whether or not, and not requiring the written summary of the recordings, since we would be requiring written minutes, if we don't require the written summary of the recordings, but we keep, I'm not suggesting we keep all the recordings made of every single hearing, but that would need to change too. I understand.
Yeah.
That wasn't my question.
Okay, so if you're not, so assuming
So
if
we require the written minutes and we require that you keep one recording, but we don't require the summary because you already got the written minutes, is that a better solution in your opinion?
Well, it's better than requiring both, but I don't see the purpose of even doing the written minutes if you're going to keep a written summary. The reason we had the written summary provision was to address when boards just wanted to use a good recording as their minutes, and nobody wants to go through and listen to 5 hours of a hearing just to figure out where in that recording the issue they're interested in was discussed. So that's why at the time the law was changed a few years ago, we said, well, be sure you have a written summary so that it tells us at what point in the recording to go to look for these various votes and discussions.
Understood. Thank you very much.
Yeah.
Sandy Ma, are you still here with Common Cause?
Yes, yes, Chair.
So, you know, the bill right now says you just got to keep these things forever. Is that necessary? Do we need? I mean, I'm a history major, so my inclination is to keep everything forever. But do we really need to keep them forever?
Common Cause's position is that for public accountability and transparency, we would like to keep it forever. You know, it is good to go back and see, you know, what has been done in the past. You know, so yes, we would like to keep it. If I could address, you know, OIP director comment that, sorry.
Unless somebody else wants to ask Ms. Ma that question, I haven't asked it. So thank you. So the position is forever is what you think should happen. Is that true even of like, I mean, you know, I was on a neighborhood board for 9 years. Does anybody really care what happened on the downtown neighborhood board in 1998?
Well, maybe the downtown neighborhood board is. I was on the downtown neighborhood board too, personally in my individual capacity. So, maybe.
Okay. I won't badge you about it anymore then. Thank you very much. Members, any other questions? Okay. Let's go ahead and move on to the next bill then, which is what is the next bill here? SB 3244 relating to legislative apportionment. This repeals the definition of permanent resident for legislative reapportionment purposes. First up on SB 3244 is Sandy Ma with Common Cause. Morning again. You're still mute. Yeah, well, you're still muted. Now you're unmuted. There you go.
Good morning, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We provided comments on 3244. We believe everyone should be counted for a fair and proper reapportionment and redistricting process. But I also want to just point out in our testimony, and I won't repeat it here, that we talked about prison gerrymandering and how that does not go to a fair and full reapportionment and redistricting process. And that is just stated in our testimony, and I'm available for any questions. Thank you.
Thank you very much. Next is Bart Dame. Good morning.
Members. Oops, it says I'm muted. Hold on.
No, I can hear you. You're good.
You can hear me? Okay. Yep. I'm testifying in opposition to this bill. It's not clear to me what the intent of the bill is. What I can see is it would remove from Hawaii Revised Statutes language which was added last year by SB 1350. Language that both sides, both the House and the Senate, claimed would clarify the meaning of the phrase permanent resident as used in the state constitution to define the population base upon which reapportionment and redistricting was based. There was a disagreement last year between the two chambers on what sort of clarification was appropriate. The Senate position up until the final conference committee was not so much a legitimate clarification, but an attempt to overrule the state Supreme Court's interpretation of the phrase rendered in the Solomon decision. The House position was to basically insert into statute the requirement that or the definition that someone was a permanent resident if they maintained their domicile in Hawaii, which is language that was taken directly from the Solomon ruling. And fortunately, the House position prevailed. I'm wondering if someone can, from the other side advocating for this bill, can explain what the intention is. What I'm concerned is while it would have no impact because the Supreme Court ruling would still be in control of the definition, it may have impact in creating confusion by removing a signpost of sorts that is in statute that reminds future commissions that they are supposed to use the permanent resident population as defined by Solomon. I'm available for questions if anyone would like to ask me any.
Thank you very much. Next, we have John Bickle for Americans for Democratic Action in opposition, Scott Smart in support, and Bronston Koso in opposition. Members, that's all the testimony we have for SB 3244. Any questions? Check. No, I have no questions either. Thank you very much, testifiers, for being here. We'll move on to SB 3309. SB 3309 is the annual statutory revision bill. First up on 3309 is Charlotte Carter Yamauchi or John Morsey for the Legislative Reference Bureau.
Good morning, Chair.
Good morning.
The Bureau stands on its written testimony in support, and I'll be happy to answer any questions you have.
Okay, thank you very much. Next is Tom Yamachika for the Tax Foundation of Hawaii
Not present, Chair.
with comments. Those are the only two testifiers we have on SB 3309. Members, any questions? Seeing none, let's thank you very much, Mr. Morrissey, for
Thank
being
you.
here. We'll move on to the next bill, SB 3329. Oh, wait a minute. Okay. Oh, I'm sorry. 3329 is we have testimony for, but it's one that we pulled from the agenda. And for those who are wondering, we're putting it back on. It's already back on for Tuesday with a proposed SD1. So that's why there's testimony, but nothing on my in my paperwork. Okay, moving on to SB 2091. This is relating to executive pardons, establishes a comprehensive application process for executive pardons. First up on 2091 is Trish Nakamatsu, Deputy Prosecuting Attorney for the City and County. Good morning.
Good morning, Chair, Vice Chair, members of the committee, Deputy Prosecutor Trish Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Office. Thank you so much for hearing the bill, Chair. This is part of our 22 package. We're in strong support. Essentially, there is currently no process for victims or our office, but particularly victims, to have any opportunity to give input before pardon. Notice of an application for pardon is considered by the governor. So currently, the only time a victim in particular would find out that an application was even filed is after they find out it's been granted. And you can imagine how troubling that can be, potentially re-traumatizing for certain victims. So this basically would provide a procedure with given timelines for the prosecuting attorney's office and the victims to provide input that could then be added to the packet that eventually goes up to the governor for consideration. We're available for questions, if any. Thank you. Oh, I would like to note that, I'm sorry, just quickly, and I'll just be a few seconds. I know the clock was running, but we did have a chance to speak with the Hawaii Paroling Authority, and there's going to be further discussion on tweaks that could be done here and there to the language to ensure that they don't have the concerns about hamstringing their process, because that's not the intent. Thank you.
Okay. All right. Thank you. Speaking of Hawaii Paroling Authority, they're next. Fred Hewen, Chair. Good morning.
Hello, Chair Rhodes, Vice Chair Gil Kalole, and committee members. Fred Hewen, Chairman of the Hawaii Paroling Authority. I stand on my written testimony, but would like to provide the following insights. While HPA understands the intent of Senate Bill 2091, there are concerns with the proposed changes to the current process that was streamlined in 2017. And I'd like to note that parole pardon is not a right, but an exceptional privilege, which only the governor has the power to grant based on demonstrated exemplary behavior. The pardon investigation process is very thorough. The investigation evaluation addresses remorse, community adjustment, which also includes subsequent contact with law enforcement after the completion of supervision, and the current status of as a positive contributing member of society, and not to adjudicate the case over again. By law, HPA and public safety are involved in the review and recommendation process to the governor. If you need a few numbers, I can provide that. Otherwise, thank you for the opportunity, and I'm available for questions.
Thank you very much. Next is Max Otani for the Department of Public Safety.
Hi, good morning, Chair, Vice Chair. First, Max Otani, Department of Public Safety. We'll stand on our written comments, and we would defer to the polling authority as to the effects this bill would have if it was passed. We'll be available for any questions you may have. Thank you.
Thank you very much. Let's see here. We have next Rebecca Leake, acting prosecuting attorney for the County of Kauai. In support, Todd Yukutake for the Hawaii Firearms Coalition with positive comments, I guess would be fair to say. Elizabeth Kent in support, and Rima Ang Atun in support. That's all we have on SB 2091. Members, any questions? Okay, seeing none. I don't either. Thank you very much, testifiers, for being here. And we will move on to the next bill, which is SB 2092. This adds a new section to Chapter 709 to establish the Class A felony offense of child torture. First up on 2092 is Chuk Fu Louis, Deputy Attorney General for the Attorney General's Office. And I'm sorry if I butchered your first name there.
Nope, you got it. Thank you.
Great.
And good morning, Chair, Vice Chair, and members. The Department of the Attorney General is in support of this measure and agrees that it is much needed. Because it is creating a Class A felony, we do recommend some minor changes, including specifically defining mental anguish and changing some of the wordings for some of the conduct. And essentially the goal is to ensure that the prohibited conduct is egregious enough to warrant a Class A felony, yet, it is not fake or overbroad, and that a regular reasonable person would know exactly what type of conduct is prohibited. We also believe that our recommended changes will address most, if not all, of the concerns from the Public Defender's Office. I'll be available for any questions, if any. Thank you.
Thank you very much. Next up, we have William Bento for the Office of Public Defender.
Good morning,
Good morning.
Chair and Vice Chair, members of the committee. My name is William Bento. I'm a Deputy Public Defender. The Office of the Public Defender does respectfully oppose this bill. We do understand that in light of recent events, the community is asking for some action to be done. However, this bill is overly broad. Subsections A, B, and C, when coupled with the reckless state of mind, can create undue prosecutions, undue arrests in this type of case. And it's very troubling that people in the public would not have an understanding of what it really is being prohibited here. When you look at sections D and E and you couple that with an intentional or knowing state of mind, it's very clear that a person cannot starve their children or feed them poisons or things of that nature. And that's clear, and that would be torturous and it should be prosecuted. However, when you take the reckless state of mind coupled with A, B, and C, and especially subsection F dealing with restraint, you will have the situation of undue prosecutions. Section F says that if a person restrains a child for whatever reason, and it could be to protect themselves from harming themselves or prevent them from harming other people, in doing so without any limit on duration, and that child tends to feel mental anguish, they could be prosecuted for child torture. The term mental anguish is not defined by the statute or the proposed statute. There's no standards. We don't know if we're talking about an objective or a subjective standard. And so when a parent uses acceptable corporal punishment to teach a lesson to a child, they could be recklessly creating mental anguish as well. And so, a parent is trying to do the right thing, but they may be subject to be prosecuted in this particular case. I'm available for any questions.
Great, thank you very much. Next is Tricia Nakamatsu, Deputy Prosecuting Attorney for the City and County. I see you here, but I don't know if you are here for this one.
Yes, thank you, Chair.
Okay, good.
Deputy, thank you so much. Good afternoon. Good morning again, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu. On behalf of the Department of the Prosecuting Attorney, City and County of Honolulu, we are in strong support of this bill. It's part of our 22 legislative package, and we thank you so much for hearing it. Well, just to respond briefly to certain comments that were made by prior testifiers, we'd like to assure the committee that this bill has been needed for years. And we've actually heard from the victim advocates community that they are so grateful something like this has come up for consideration, because the existing statutes regarding abuse simply don't account for those unfortunately tragic instances of generally caretakers, parents who are doing things to their children that simply may not rise to the level of physical assault, but whose actions are clearly not properly accounted for, deterred, or even punished by a misdemeanor charge under our current abuse statutes. The focus of this particular statute, the way it was written, is on the mental anguish portion. And if the definition needs to be added, we've had a chance to speak with the AGs further, or if it's really meant to be a severe mental pain, suffering, distress, not just your typical stress or the child's crying because they're sad they got a spanking, but this is really something that tends to be rather extreme. And when you hear the facts of these cases, it becomes very, very clear that an additional level of offense is needed. Whether that language is tweaked, whatever changes need to be made, we're open to discussion. We're happy to answer any questions, but we do feel that it's very needed. And thank you so much.
Thank you. Next up is Alan Bartolome for the County of Hawaii Office of Prosecuting Attorney in support. Marilyn Yamamoto for Hawaii Family Advocacy Team in support. And then we have, it looks like 11 individuals all in support. Okay, that's it for the testifiers on 2092. Members, any questions? I do have a question for both Mr. Bento and Mr. Louie. Am I correct in that, is it true that the federal government, I'll start over again. Does the federal government have a similar crime?
I don't believe they have a similar child torture crime. They have just torturing, and that is essentially not a crime. It was more in the context of interrogating the terrorists and what would constitute torture.
Do you know, did they use a reckless state of mind in that statute?
I don't believe so. I'll have to look at it, but it was different, and they don't use the word mental anguish. They use the word prolonged mental harm, but it is also not defined.
Thank you. Do you have anything to add on that, Mr. Bento?
I'm unaware of any of the federal statutes. I'm sorry.
Okay. All right. No problem. Okay. Thank you both. Members, any other questions on 2092? If not, thank you. We'll go ahead and move on to SB 2096. This lowers the threshold for blood alcohol content for the offense of operating a vehicle while under the influence from 0.08, which is the current standard, to 0.05, which is a standard in Utah and much of the rest of the world. Let's see, first up on 2096 is Deputy Director Sniffen for the Department of Transportation, or Director Butai.
Good morning, Chair. We stand on our testimony in support. Thank you.
Thank you. Next is Acting Major James Slater for Honolulu Police Department.
Good morning again, Chair, Vice Chair, members of the committee. James Slater, Honolulu Police Department's Traffic Division. We submitted written testimony in strong support of Senate Bill 2096. If I could just add a couple of points. As you mentioned, Utah does have the 0.05 law in effect. In 2019, they saw an 18% decrease in traffic fatalities. So they did show that it was working. A lot of the naysayers, they do like to bring up that 2020, the traffic fatalities rose. But if you look nationally, the numbers went up, period. And we also saw a very large uptick in drug use. I think that can be attributed a lot to the COVID situation, depression. So not necessarily did that say that the 0.05 law did not work. As you know, the 0.05 law is in effect in Hawaii if you're involved in a motor vehicle collision. So I'll just give you a really brief scenario to kind of get your mind going with this, because it's interesting, and from my perspective, that if I go out to have dinner with some friends, I have a few drinks, and in my mind, I'm thinking I'm okay to get behind the wheel, you know, and I'm wrong, but I get behind the wheel, I'm driving home, I stop at a red light, I'm sitting at the red light, I get rear-ended by another vehicle, not my fault at all. That other person was distracted. The officer comes on scene, notices that there's indicia, I have signs of impairment, runs me through the standardized field sobriety test. I fail, I come in, I blow a 0.05 or over, I'm arrested for OUII. Same exact scenario. I'm driving home, but now I'm weaving. Officer sees that, wants to stop me before I kill somebody or myself, pulls me over, runs me through that standardized field sobriety test, determines that I am impaired, brings me in, I blow that 0.05. It's not arrestable. You can kind of see the difference in that it's kind of hard to understand why. Either way, 0.05 and above, I'm impaired. It does dramatically affect your ability to safely operate a motor vehicle. And I would just ask that we've been trying to pass this law for years. And I would just ask that Hawaii think about being proactive versus reactive. Hawaii Move Over Law, we were the 50th state to pass that. And it took the loss of lives of officers and tow truck drivers. So I would just ask that you consider it.
Thank you very much. Appreciate your being here. And there may very well be questions for you. Next up is Sarah Haley for the Office of Public Defender. Good morning.
Good morning. And again, Deputy Public Defender Sarah Haley on behalf of the Office of the Public Defender. Generally, we are going to stand on our written testimony in opposition, and I am available for questions. However, I did want to briefly address one of the arguments that HPD just made. I'd strongly encourage each of you to actually review NHTSA's report on the results of the 0.05% change in Utah. I addressed it in my written testimony in a footnote 1. That report is actually quite misleading, and I'm no expert statistician, but if you just look at the figures in the NHTSA report, it makes it clear that there was not an obvious decrease in fatalities just because of the passage of the law. If you look at the rates of fatalities, they actually go up and down over the past 10 years. And in 2012, as well as 2013, there was similarly low rates of fatalities. So it's not clear that the change in the law actually reduced fatalities in Utah. So again, anyone with common sense can take a look at NHTSA's own report and its own graphs and see that that is not the case. Otherwise, I'm available for questions. Thank you.
Thank you. Next is Kelly Takaya King, Maui City Council and HSAC Vice President.
Aloha, Chair Rhodes.
Oh, well, there you are. Good morning.
Good morning. Good morning, Honorable Committee, and thank you for having this hearing. I really appreciate hearing this measure. We stand on our support for this measure. And I just wanted to add initially that I had proposed this to HSAC and to the Maui County Council package because I've been working closely with the police who strongly believe that this measure will make a difference. We've had a huge increase in traffic fatalities on Maui just in the last year. And yes, some of it may be related to COVID, but a lot of it's related to drinking. And I constantly explaining to friends of mine who like to drink that this is not a bill limiting your ability to drink. It's limiting your ability to drink and drive. So that's what we have to stay focused on, that we're all safer when people don't get on the road after they've had 2 or 3 drinks. And hopefully you folks will pass this on and we can continue discussing it. Thank you very much.
Thank you. Thank you. Thank you for being here. Next is Michael Sparks for Sparks Initiatives.
Not present, Chair.
In support, Cynthia Okazaki for Hawaii Alcohol Policy Alliance.
Hi, Chairman Rhodes and
Good morning.
members of the committee. Thank you for letting me testify. I am a member of the Hawaii Alcohol Policy Alliance, and we are in strong support. You have my written testimony, and we've cited the NHTSA's report. And if you have any questions about that, we'd be glad to answer your questions. And I think just to emphasize what the councilwoman said, that this will affect people who drink and drive. It will not affect the average driver. So I think that for those reasons, and because it will save lives and other harms caused by this drinking and driving, I'm in strong support and urge you to pass this bill. Thank you.
Thank you very much. Next is Rick Collins for Hawaii Public Policy Institute.
Good morning, Chair and Vice Chair, members of the committee. Thank you for hearing this bill. My name is Rick Collins. I'm here with the Hawaii Public Health Institute, and we are in strong support of this bill. We stand on our written testimony and support. And I just wanted to highlight one piece of that testimony, and that is that if we do lower this BAC limit down to 0.05, we are very likely to save lives and improve our traffic safety. There was a recent National Highway Transportation Safety Administration report that was released last week, Friday, dated on February 11th. It evaluated the 21 months after Utah passed their new BAC law down to 0.05. There was a significant drop in fatal car crashes in that report, stating that there was a 19.8% drop in car crashes compared to the rest of the US, which only saw a 5.6% reduction in fatal car crashes in that same period. So this study's real world results validates what NHTSA has been recommending for years, I believe since 2013, which is to lower the BAC limit across the United States. We believe it can save lives across the US, and we particularly believe it can save lives here in Hawaii. So we ask for your support, and thank you for allowing me to provide testimony.
Thank you very much. Next up is Chelsea Gonzalez. Good morning.
Hi, here. Good morning. Good morning, Chair, Vice Chair, members of the committee. I'd also like to stand on my written testimony, but I'd like to highlight one other point. I really appreciate the discussion that we're having here. But in the NHTSA report, I wanted to just highlight that lowering the BAC limit to 0.05 will not reduce alcohol sales, tourism, or tax revenues. So since the law that went into effect in Utah, when they studied during that time period, there was no decline in any of these areas, right? So alcohol taxes, tourism, and tax revenues. Alcohol sales and tax revenues from restaurants, car rentals, hotel, air travel, and resort sales have actually continued to trend upwards following the implementation of the new law. So I just wanted to highlight that piece, and I'll stick around for any questions. Thank
Great.
you.
Thank you very much. We have Maui Prosecutor's Office in support, William Hankins for Maui Police Department in support, Paul Ferreira, Chief of Hawaii Police Department in support, Alice L. Lee for Maui County Council in support, Kirk Kindrow, Public Policy Committee, Mothers Against Drunk Driving in support, Richard Berman for American Beverage Institute in opposition, Luis Salaveria for the Wine Institute in opposition, Lorraine Martin, President and CEO for National Safety Council in support, Kawina Bagano for the Hawaii Alcohol Policy Alliance in support, Becky Harrison for Habilitat in support. And we have quite a number of probably 15 individuals, all but one in support. Okay, that's all the testifiers we have on SB 2096. Members, any questions? Senator Lee, go ahead.
Thanks. Is the public defender still here?
Yes, I'm still here.
Hi, thanks. Your testimony suggests ultimately that some drivers at a 0.05% blood alcohol concentration do not exhibit the kind of impaired skills that cause them to drive unsafely, suggesting some do. And then I believe your testimony basically says, the gist of it is that this casts too wide a net. Is that right?
So we are saying that a 0.05% is not going to create an impairment that needs to be criminalized in the way that this statute is trying to do so. And the only recent information that we've received, which is the NHTSA report everyone's discussing, concerning whether fatalities might be reduced by implementing a 0.05 BAC, as I just recently stated, the study actually doesn't necessarily show that. It essentially takes 1 year and compares it to one other year, which is actually quite misleading. Yeah.
Pausing just there, just on the study, because I think obviously Utah is one thing, 100 other countries, and we can look at studies all around and everybody can argue about that stuff. But what I was curious about was with your testimony at 0.05%, some drivers are impaired.
Oh, well, so you're talking about when you look at like 100-pound woman who drinks 1 or 2 drinks, that would put her at 0.05%. We are saying that does not mean that you are impaired to the point that it needs to be criminalized. So does that answer your question? Because our concern is, oh, sorry, go ahead.
Well, what I was getting at is whether you're a man or woman or anybody, and I have huge friends that just have a really low tolerance and become impaired drinking an embarrassingly small amount of alcohol. It seems like the law and the threshold that we set has to apply broadly into everybody. And the suggestion that having some people who are impaired still legally able to drive doesn't seem to make sense to me. So I was It seemed like what you're arguing is it's okay to have some people who are legitimately impaired on the road without being criminalized.
Oh, I see what you're saying. Okay. I guess what's difficult is what is your definition of impaired, right? So does it mean that does impaired mean that it is affecting your driving so that you are dangerous in some way? So I guess if that is how you're defining impaired, then our argument is that no, so a 100-pound woman that's had one drink is not dangerous and impaired in a meaningful way in her driving. So I think that might answer your question. But what we're saying is the 0.05 is not a proper BAC. I mean, you could say that at 0.01, maybe alcohol might affect someone in a very tiny way, but that doesn't mean that they're impaired to the point that it would be a danger to others for them to be driving.
Thanks. Then Chair, if I could just follow up with HPD with one question.
Let me go to some other people first, and I'll come back to you if that's okay. I have Senator Gabbard and then followed by Senator Kim. Go ahead, Senator Gabbard.
Thank you, Chair. For DOT, Chair, you mentioned this, and also Senator Lee referred to it, the studies that have been done in other countries where this law is in effect. I would just like to know from DOT, can you give us a brief summary, if you've looked at what those results are, how successful this has been in other countries?
Chair, if you don't mind, can I have Bob Blunt?
Sure, go ahead.
When they speak of other countries, we're speaking mostly of like Australia or in Europe, which has been a more or less even a zero tolerance on alcohol. And their percentage of fatals due to crashes isn't large at all. As for studies coming out of that, we haven't seen it, only through traffic safety news. But to bring it down here, what these are doing, as I stated in a report, for a period of like 5 years, over 19,000 arrests were made. And all of that particular arrests, all the arrests, about 878, which includes about 5% of those would have between a 0.05 and 0.079. Now, these people were arrested because mostly of their behavior on the roadway on this. And so that substantiates, especially down here, that these people were all over the road, you know, and were a danger to other people. And that's why they were stopped and subsequently arrested. And again, as the Captain Slater said, when you bring them in and they didn't blow a 0.08 or above. It was all below 0.05 to 0.079 on that. So it would be a dangerous, but Europe more or less has had their long standing of low tolerance of BACs for a long time. And their fatality rate are, you know, down or below.
Okay, thank you very much. Thank you, Chair.
Thank you, Senator Kim.
Yeah, I wanted to ask, I guess it could be the police or it could be DOT. How many of these fatal fatalities actually were from individuals that tested between 0.05 and 0.09? I mean, 79.
Yes, Senator Kim, we're trying to look that up now, but there have been several fatalities that when arrested, they were below a 0.08 on this. As to the number,
So, yeah, if we
I
can
can't say.
number to us, because you know this bill was introduced last year or failed to pass last year, and I had concerns about it because I agree and I want to keep people off the road, but we want to deter people. And so I'm not sure that somebody like myself who may have one glass of wine, that it deters me because I'm not sure what I'm going to blow 0.5 or 0.79 or 0.8. I mean, I shouldn't be driving at all then. I mean, so, you know, I can probably drink one glass of wine and I'm not impaired and I can drive, but like they said, if I get hit from behind And I'm not the one that's, I've had one drink. I say I blow at 0.6. And now I ain't even in the accident. Somebody hit me from behind and I got to go. I blow and then now I'm 0.6. And then I get arrested. I get criminalized.
Yes. As far as the statistics, maybe my counterpart in the office can help. Can you unmute Leanne Yamamoto?
Yeah, go ahead.
Go ahead, Leanne.
Can everyone hear me?
Can barely hear you.
Okay, I made it a little louder. I found some statistics and I think it might answer the other questions. According to NHTSA study, the risk of being killed as a driver in a single vehicle crash is 6 to 17 times greater for drivers at BACs between 0.05 and 0.07 compared to drivers with 0 BACs.
My question was not, my question was not most likely. My question was what is the fatality accident based on that amount?
Oh, okay, I'm sorry.
Because you could say most likely if you even have a drop, you could mean, right? I mean, most likely it's like, what are fatalities? I keep hearing everybody talk about, we have the accidents went up, the accidents went down, so forth. So what is the actual numbers?
Sorry, I don't have the BAC numbers on that. We can look it up and get you that information.
Yeah, I wish you folks would get that, because I tend to agree with the public defender that you're criminalizing people and we want to keep people off the road. And that determination is, people make that determination personally. And I'm not sure that somebody now who drives, who've had one drink and is at 0.5 will feel that, oh, now it's at 0.5, I'm not going to drive. Right? We want to keep them off the road, so that decision is made personally. Because it's at 0.8, you're not going to drive, but because it's at 0.5, you're not going to drive. I mean, I'm not sure that somebody even knows the difference, because somebody like me who weigh a little over 100 pounds, if I gain weight and I'm at 120 and I've done that, I mean, that, might not affect me. But because if you lose weight and you're less and you drink, I mean, how do you know that? How do you know how it affects when I blow? But I know that I'm not impaired. I'm not 120, I might be impaired at 105. Okay, thank you, Chair. I don't
Okay,
know.
thank you. I'll come back to Senator Lee. Go ahead.
Well, thanks. Yeah, so I was just going to follow up with HPD, if you're still here.
Hi, Senator.
Hi, thanks. Well, first of all, just to the point I think Senator Kim had raised about if you are now driving at, whatever, 0.05, 0.06, you hit somebody, cause an accident, isn't the law as it exists right now already going to penalize you as a result of that?
That is correct. It would be the same as if you were a 0.08 and not involved in a motor vehicle collision. And I'd like to kind of help clarify a lot of, first of all, kudos to the committee. I'm loving that we're having a good, healthy discussion about it, because in years past, it's been written testimony and it dies. So this is great. But just to move on to the points that everybody's been making about if I'm this weight.
I'm sorry. So Senator Lee, is this the question you're asking? If you want to ask that question, that's fine. But
yeah, no. The one I was going to ask in particular was coming from the discussion we had a little bit ago with the public defender at 0.05. That it should be okay to have people who are at a 0.05 level who are impaired, regardless of who they are or weight or anything like that. This would close that loophole that allows people who are impaired to legally drive on the road.
Correct. So if you are, regardless of your height, weight, size, gender, if we see, you have to see signs of impairment, right? We can't just arrest you, because we can't look at you and say, this is your BAC, because we know. You're going to take a standardized field sobriety test. To Senator Kim's point, if you were involved in a collision and you only had one drink and you think you're okay, and we run you through the standardized field sobriety test and you passed, you don't get arrested. And even if you are a 0.05, 0.06, 0.07, because we don't know that you're a 0.05 through a 0.07, right? It's based on the signs of impairment. It's the totality. It's based on your ability to perform the standardized field sobriety test, your driving habits. These all come into play. So it's not just the one thing of size, weight, gender. It's your level of impairment.
Thank you, Chair.
Okay, I'll go back to Senator Kim. Go ahead.
Okay, so officer, so right now, if I'm at 0.05 and I get into an accident and I'm not impaired, pass all the tests, then I'm not arrested.
That is correct.
Okay, but if I don't pass all the tests, then I'm arrested, even though it's at 0.08.
Yes, if you don't pass the test and you have signs where there's a lot of different things that we need to go through as officers to prove, we can't just arrest you because we are taking a guess.
So then why do you need that? If I'm at 0.5 and I am impaired and I don't pass the test, then I get arrested anyway, right?
Right, but then when we bring you into the station and we know that you're impaired, you failed the standardized field sobriety test, regardless if you're involved in a motor vehicle collision or not, you are an unsafe, unfit driver to be on our roadways. You're causing a public safety issue. We bring you into the station, you blow and you blow under a 0.08, we let you go. But you were still a public safety risk. You were still a hazard on the road. You just didn't get caught getting involved in a collision, right? But if you were involved,
but you did get caught. You did get caught, right? I mean,
if you were involved in a collision and you failed the sobriety test, and we bring you in, then yeah, you do get arrested for the.
I get arrested anyway.
But the point is, Senator, either way, whether you're involved in a collision or not, we're saying you're an unsafe driver, right? Like your driving habits.
But you're trying to get people to stay off the road, right? You're trying to get people to stay off the road, so that has to be a choice.
One at a time, please.
Yeah, so that has to be a choice. So, but if in the case where I get hit from behind and I'm at 0.5, I get hit from behind and you take me in, and if it's at 0.5, the law is at 0.5, then I get arrested?
Yes.
But I'm not
impaired. If you fail the sobriety test.
Yeah, but I'm not impaired. What if I meet the sobriety test, but I blow and at 0.5 and the law is at 0.5?
If you meet the sobriety test, Senator, you don't get arrested and we'd ever take you in to blow.
So, but I didn't cause the accident, so I still got to blow?
No. So if you are involved in a motor vehicle collision, regardless if you were at fault or not, we are looking at the totality if you appear to be impaired. If you do appear to be impaired, we ask you to participate in the standardized field sobriety test. When you take that standardized field sobriety test, if you fail and there are signs of impairment, then you can get arrested. We take you into the station. If you blow a 0.05 or higher, you get arrested for the OVII. If you're not involved in a collision and we see signs of impairment, you fail the standardized field sobriety test, we take you into the station and you blow a 0.05 up to a 0.08, you don't get arrested. You don't get charged, rather, if that makes sense.
But you get arrested.
Yeah.
Arrested. Okay, thank you.
Okay, thank you. Any other questions, members?
Yeah, Chair.
Oh, yes, sir. Senator Favela, go ahead.
I got a question. So how long after your first drink, I guess this can go to HPD. I mean, because I don't know about these sobriety tests, but how long after your first drink, usually depending on the circumstance, after your first drink, you get in your car, and similar to what Senator Kim said, you get into an accident. How long does that until it doesn't register that point that you're talking about?
It can dissipate at different rates for different people, depending on how it metabolizes. So there is no one shot. There's lots of different studies. I have drug recognition experts that could probably provide you like a lengthy report to explain more for you. But realistically, it's the whole idea behind this is if you're impaired, we don't want you getting behind the wheel. That's the bottom line.
Sorry to go back again. Clarification. So back in the day, I'm 200 pounds. Of course, I'm not 200 pounds now, but when I was 200 pounds back in the day, when I used to have alcohol consumption, I could drink 6 beers and not be impaired. And we used to do that test all the time because it was something new at the time. And now we want to lower the level because of the blowing, and the person might not be impaired, but because of the alcohol on the breathalyzer test, it's that we fail and we're subject to arrest and losing our license. That's the part that I have, like you just said now, Captain, you just said, it depending on the person or depending on the circumstance, it also go by weight too. So that's why I really wouldn't understand, because by doing the breathalyzer test, I could do mouthwash, get banged by one car, do the breathalyzer test, I probably fail. That's the part that I have a hard time swallowing going forward, because I really don't think that person would be impaired depending on the circumstances. So that's just my thing. I mean, I don't know if you have an answer, but you just said depending on the circumstance and the weight or whatever. I just think that, no, I mean, I don't know if you can answer that. Sorry.
So if you were to just put some breath wash in your mouth and you're driving and you get into a collision, when the officer arrives, first of all, we can tell the difference of smell between breath wash and alcohol. But if we were to pull you over and we don't see any signs of impairment, and even if we smell alcohol, right, and we don't see any signs of impairment, we may ask you to participate in a standardized field sobriety test. I'm assuming this mouthwash didn't cause you to become impaired, so you're able to perform the standardized field sobriety test and you pass. It never gets to the point where you go to a breathalyzer to blow the 0.05, because it would never get to that point. You're not impaired. So it's based on your level of impairment, not on your BAC. What we're saying is if you're involved in a collision or whether you're not involved in a collision, 0.05 does, it's typically the number that if you are impaired, you're unable to operate a vehicle safely.
Okay, so thank you for saying that about doing the roadside test. I'm 6 feet, 350 pounds. I don't even see my feet, let alone do a test like that, even right now. So even if I don't smell alcohol, you said you could smell red wash. What if I drink peppermint schnapps or some kind of fruity beverage that doesn't smell like alcohol? Even at this time, if you make me do this test right now, Captain, I'll fail the test. I can't even see my feet. You know what I mean? I'm not coordinated. So the test is not actually for an impaired, it's for somebody who's coordinated. And I'm not fussing on some of the women out there that is probably more athletic and more easy to do on tests. I'm just saying that there's flaws, not only within this bill, but even with the sobriety test, because I cannot take one even if I'm sober. So that's what I'm trying to bring up. Having that low of a level, I don't want nobody driving impaired, period. But having that level reduced still calls to question, because a person like me who's clean sober cannot pass a roadside sobriety test. And I'll have a lot of officers friends that we did, and I cannot, seriously, because I'm not coordinated like I used to be when I was young. So it goes with age too. Yeah, thank you.
Okay. Thank you. Senator Kim.
So let me follow up on Senator Favela's questions, Captain. So what troubles me is that you have officers that will use their discretion, right? Isn't it based on discretion whether or not they think that you might be impaired, or that they feel that they smell something on your breath, whether it's alcohol or not, or mouthwash? They have that option, right?
Correct.
Okay, and that's a problem, because I hear from a lot of people where officers will pull over somebody and, and they'll just say, you know what, I think you're impaired, and there's nobody to argue that, and they make them take the sobriety test. They make so happen that they, if they didn't have it, they're being harassed, and that if not, that they 0.5. But now it's like, many times that's what happens, is it's subjective.
If the officer, I'm not sure if there was a question, but if you have, as an officer, you're observing poor driving habits, weaving in and out of the lanes, no turn signals, erratic speeding, slowing down, a lot of different things. Pull the vehicle over. It's a totality. Bloodshot eyes, a strong alcoholic beverage smell coming from their breath, slurred speech, inability to physically manipulate things. So it's a totality. It's not just, I think you're drunk, so I'm going to arrest you. There's a lot.
Come on. I agree, but in reality, when you get stopped, and I've had friends and people get stopped, they didn't put their blinker on and they're not, but the officer put them through it. If the officer don't like how you look or how you act or how you talk or you sound sassy, they put you through it.
I think that's probably the topic of a different bill, but.
I understand. Okay.
Okay.
Thank you.
Members, any other questions? Okay, if not, I have a question for a public defender. You're still here.
I'm here.
So I have to admit, I'm a little surprised that you guys are, I know usually when you come in and testify, I at least understand why you're saying what you're saying, because it's, you know, you want to be sure that defendants have the rights that they're entitled to under the law, and that there's no fundamental unfairness is taking place or unconstitutional or otherwise. But I guess I'm a little confused why you care, why the public defender cares what the alcohol level is. What freedom is it that you think is being impinged on?
So as we indicated in our testimony, we are concerned about people who are not impaired in their driving having their behavior criminalized. And DUI is a non-deferrable defense, so it stays on your criminal record for the rest of your life. Not to mention that you would be arrested and taken in. I also did want to note that as from a legal standpoint, we also, the state can also prosecute DUIs based off of 291E61 subsection A1, which does deal with an impairment. So they do have an option that is not just based off the BAC.
But if we set, as some countries have, I believe, if we set the tolerance level at 0, which I believe we have the authority to do if we had the votes to do it, why is that? I'm still not sure what the problem with that is. You don't have a right to drive. You have to be licensed, and I think the studies indicate that any amount of alcohol does have some impairing effect. So isn't this just the legislature's call?
Well, again, we are going to be representing those that are charged with this crime. And again, our position is that it's criminalizing behavior that is not actually impairing. Correct. That's not rising to the level of being dangerous and driving. And as I just stated, we already have a law in the books that covers impaired driving that doesn't even relate to the BAC. Yeah, so if someone is impaired driving due to alcohol, the state can and does charge under that subsection A1. Okay. So they still have an option.
I appreciate it. Thank you very much. Mm-hmm. Okay, I think we've talked about this one long enough. Let's go ahead and move on. Thank you all the testifiers for being here. Let's go ahead and move on to SB 2136. This prohibits jury exclusion based on gender identity or expression. First up on 2136 is Michael Galoyu Jr.
Good morning. Happy aloha from Michael Galoyu Jr., Chair of the Stonewall Caucus for the Democratic Party of Hawaii. We stand in strong support of this legislation. We're sorry that it's even necessary, but as we've heard, it is. So we hope that you will pass this bill and support it as we move forward. Thank you for the time, and I'm available for questions. Mahalo.
Thank you very much. Next is Michael Galoyu Sr., testifying for Rainbow Family 808 in support. Eileen McKee in support. Michael Older in support. Nikos Leverance in support. And Joseph Brown III in opposition. That's all the testimony we have on SB 2136. Members, any questions? Okay, not seeing any. Let me just double check. Nope, we're good. Let's go ahead and move on to the next bill, which is SB 2114. This updates the purposes of the Children's Justice Program to include investigation and management of cases involving suspected or confirmed child sex trafficking, commercial sexual exploitation of children, other child maltreatment, and child witnesses to crime or violence. First up on 2114 is Farshad M. Talebi, Deputy Attorney General.
Aloha, Chair, Vice Chair, members of the committee. Can you hear me?
Yes, yes, please proceed.
I'm Deputy Attorney General, State Human Trafficking Coordinator Fashad Talebi. The department strongly supports this bill. The Children's Justice Program plays a vital role in the criminal justice process and supporting child witnesses and victims, and we think it would be valuable to expand the purpose in the statute. So we respectfully ask the committee to pass the bill, and I'm available for any questions.
Okay, thank you. Next up is Keith Hayashi for the interim superintendent for the Department of Education.
Not present, Chair.
In support, Brandon Nakasato, Captain, Criminal Investigation Division, Honolulu Police Department.
Also not present, Chair.
In support, Trisha Nakamatsu, Deputy Prosecuting Attorney for the City and County of Honolulu.
Not present, Chair.
In support, Paul Ferreira, Police Chief, testifying for Hawaii Police Department. In support, Lynn Costalis Matsuoka, Associate Director for Sex Abuse Treatment Center.
Not present, Chair.
In support, Shayna Wailana Pukila.
Aloha, Chair. Thank you for allowing me to testify today. Aloha Committee. I'm in support of SB 2114, but my testimony just included Title II of the American Disabilities Act. And I want to make sure that the CJC and child welfare, as well as the family court system, follows this guidance, because this is compliance with federal law. So I don't see on any of SB 2114 any provision for the disabled, either parents or children. There's no provision for auxiliary aids that can be provided for nonverbal or speaking different languages. So I want to make sure that the Children's Justice Center provides justice for children that are disabled and have other languages as well. I also want to remind them that, the National Center for Missing and Exploited Children in 2016 said that 1 in 6 were likely sex trafficking victims, and 86% of these sex trafficked victims were in the care of social services or foster care when they went missing. There is a problem with child welfare services not properly supervising children in their care. So in 2014, the Survivors Network of Those Abused by Priests filed a complaint against Catholic Charities and a Hilo social worker, and this is on the record, for sending several children to a convicted felon for sex exploitation. He was from Florida, and he became a foster parent. And this social worker kept sending children to him. So that's never been investigated. And the Hawaii County Prosecutor's Office is urged to look into that. I have information about that if anybody wants to know. But main thing is that the CJC and the family court system and law enforcement follow Title
Thank you
II.
very much. Your 2 minutes is up. Thank you very much. Next up is Jasmine Mao Mukai.
Good morning, Chair,
Good morning.
Vice Chair, and members of the committee. My name is Jasmine Mamukai. I'm the director of the Children's Justice Center. I'm testifying on behalf of the judiciary in support of SB 2114. And really the purpose of this bill is to ensure that all children, despite the type of harm, including trafficking of minors and children who witness violence and crime, receive services that are comprehensive across the state. Thanks for the opportunity to testify. I'm available for questions.
Great, thank you very much. Members, everyone else on the list, and there's quite a few, both organizational and individual, are in support. And because we're running out of time, I'm just going to leave it at that. Members, any questions for those who have zoomed in today? I can't see the whole screen, so you'll need to shout out if I'm ignoring you accidentally. Okay, seeing no other questions, members, I'm prepared to go straight to decision making. If you guys are, anybody want to go to the breakout? Okay, all right, let's go ahead and go to decision making then. So we'll go back to the top of the agenda. This will be SB 2163 relating to negligent homicide. Makes it a Class A felony for a person to cause the death of another while operating a vehicle in a negligent manner and under the influence of an intoxicant if certain aggravating factors are present. I think I'm going to pass it, recommend that we pass it as is. I think we're good to go on this one. Questions or concerns? If not, Vice Chair Keo Kaloli, which I can't see, I guess you're here somewhere. There you are. Okay, for the vote.
Members passing unamended. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela.
Reservation.
Chair recommendation adopted.
Thank you, members. Next up is SB 2856. This requires the court to extend the duration of a restraining order or protective order issued against a pretrial detainee if the detainee is granted a motion for pretrial release. Our recommendation here is to pass forward with some amendments. It would require the court to issue, so there's this jurisdictional question, so require the court, which is generally a circuit court, I believe, to issue a no contact order against a pretrial detainee if the pretrial detainee is granted a motion for pretrial release, and then the no contact order would be for the pendency of the case, provided that the charged crime pertains to the complaining witness and the judge is aware of the restraining order or protective order or TRO or whatever the specific order is. So it needs to be tied to the person that you're issuing the no contact order for, and it would last for the pendency of the case. So there wouldn't be any question about when it's supposed to end. Questions or concerns? If not, Vice Chair.
Members voting on SB 2856, the recommendation is to pass with amendments. Noting the presence of all members of the committee, are there any noes or reservations? Chair recommendation adopted.
Thank you, members. Next up is SB 2869. This allows obligees under an order solely for spousal support to elect to enforce the order pursuant to the regular civil debt collection chapters rather than through the clerk of the court. Recommendation here is to pass with some amendments to accept the AG's clarifying amendments, including removing section 2 of the bill and other unnecessary references to the Child Support Enforcement Agency, which does not enforce orders solely for spousal support. Questions or concerns? If not, Vice Chair.
Members voting on SB 2869, the recommendation is to pass with amendments. Noting again, all members are present. Are there any reservations or no votes? Seeing none, recommendation adopted.
Thank you, members. Next up is SB 3172. This provides that any electronic audio or visual recording of a board member shall be maintained as a public record. The recommendation here is to pass with some amendments to clarify that the requirement that any electronic audio or video recording of the meeting be maintained, that has to be maintained, be referring to a recording made by or on behalf of the board, and they only have to keep one. Sometimes more than one video is taken. At the request of the introducer, I'm also going to suggest that we amend it to, since we'll be requiring written minutes, we will take out the requirement that the boards have to do a written summary of the video recording, but we'll require that the video recording, we still require that the video recording or audio recording still be kept archived. Questions or concerns? Senator Kim.
A question, and you brought this up about they have to keep it forever. What is the impact of that, keeping stuff forever? And I'm not sure whether or not the technology changes that whatever is kept is going to be usable. Because in the past, if we kept it on CDs or you kept it on little, disk, and now some of the computers can't read it, or.
Yeah, no, that's a fair question. I probably should have used the word indefinitely. Nothing's forever, but sometimes certain records have a drop dead date where you just don't keep them anymore. Considering the cost of memory, which is lower and lower every day, as far as I can tell, I don't believe that's an onerous requirement. But yeah, that's that would be my recommendation, is go ahead and leave that in, that was in the bill, and go ahead and leave it in.
And the minutes is electronic written minutes?
No, the minutes, what the bill requires is that the boards keep actual written minutes. But
Written minutes on paper.
Yeah.
So how long do they keep that? Forever as well?
That's what it says, yeah.
I know, I'm just saying
I'm not suggesting that we change it, that's what it says.
But how do you keep forever paper and store it?
Well, I don't think there's no prohibition on maintaining it electronically, but you'd have to have written minutes. So, I mean, I suppose you could leave it on a Word file and there's no problem. I don't see that there'd be any prohibition against that, but there wouldn't be a time deadline when you'd have to destroy them.
But you would have to have the paper file, even though you have it
No,
electronic.
I don't believe the bill says that. It just says they have to be written minutes, which means in this day and age, it's in a Word file.
Right, that's what I was saying, and you said,
Yeah.
that's why I said written on paper. Okay,
No,
thank you.
I don't know. I don't believe the bill requires that.
Thank you.
Anything else? If not, Vice Chair.
Members voting on SB 3172, the recommendation is to pass with amendments. Members, are there any no votes or reservations? Chair, recommendation adopted.
Thank you, members. Moving on to SB 3244. This relates to legislative reapportionment, repeals the definition of permanent resident for legislative reapportionment purposes. As you're well aware, we moved a Con-Am a while back. I'd like to keep this bill alive. I'm not sure what the interplay between those two will be. So let's pass it with an effective date, July 30, 2075, and continue the discussion. Questions or concerns? If not, Vice Chair.
Members, SB 3244 passing with amendments. Are there any reservations or no votes?
No.
So noted. Chair, noting the opposition of Senator Ocasio, all other members vote aye. Recommendation adopted.
Okay, thank you. Next up is SB 3309. This is the statutory revision, the annual statutory revision bill. There were three sections that we felt were a little more substantive than what should be in this bill. So recommendation is to remove section 3, 11, and 13. Questions or concerns? If not, Senator Pio-Colole.
Members voting on SB 3309, the recommendation is to pass with amendments. Are there any reservations or no votes?
Reservation.
So noted. Chair, recommendation adopted.
Thank you. Next is SB 2091. This establishes a comprehensive application process for executive pardons. Recommendation here is to move it along. I'm before the Donald Trump era. I'm not sure I would have cared about this bill, but I think it's pretty clear that you can abuse the pardon power. I don't believe it's happened here in the state, but I think it's worth discussing some more. So suggestion is to put on a bad date, July 30, 2075, and they're also text. Questions or concerns? Not, Senator Pio-Colole.
Members voting on SB 2091, the recommendation is to pass with amendments. Are there any reservations or no votes?
Reservation.
Reservations for Senator Favela. Otherwise, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 2092 relating to child torture. Recommendation here is to pass with some amendments. I'd like to accept the AG's recommended amendments. So to amend the bill by adding in a new section, a definition of mental anguish, and then changing subsection 2D, page 2, lines 4 through 6, change the description of the things that someone would have to do to torture them, hopefully make it clearer. And also on page 2, line 12 and 13, about the physical restraints, and try to clean that language up a little. So basically they're basically text, the same general idea of what we're trying to do. Questions or concerns? If not, Vice Chair.
Members voting on SB 2092, the recommendation is to pass with amendments. Are there any reservations or no votes? Seeing none, recommendation adopted.
Thank you very much. Next up is SB 2096. This lowers the threshold blood alcohol content for the offense of operating a vehicle under the influence of an intoxicant. Recommendation here is to pass it with some amendments. I'd like to conform, there are other sections where this is mentioned, and would like to conform those other sections to the to what would be a new and lower blood alcohol content level if this measure passes. Questions or concerns? Senator Kim.
I just want to explain my vote. I will be voting no on this measure, and it's not because I don't believe, I feel that people who are impaired shouldn't be driving, no matter what whatever level they are. However, I also don't believe that people should be criminalized just because they blow 0.05. So I will be voting no. Thank you.
Okay, thank you. Any other concerns or questions? Seeing none, Vice Chair.
Members voting on SB 2096, the recommendation is to pass with amendments. Noting the opposition of Senator Kim, members, are there any reservations? Okay, any other no vote?
No vote for me.
So noted. Okay, Chair, recommendation adopted.
Okay, thank you very much. Next is SB 2136. This prohibits juror exclusion based on gender identity or expression. Our recommendation is to pass as is. Questions, concerns? If not, Vice Chair.
Members, SB 2136 passing unamended. Are there any reservations or no votes? Recommendation adopted.
Thank you, members. Next up is SB 2114. This updates the purpose of the Child's Justice Program. Recommendation here is also to pass unamended. Questions or concerns? If not, Senator Kale Kaloli.
Members voting on SB 2114 passing unamended. Are there any reservations or no votes? Recommendation adopted.
Thank you very much, members, for being here, and we'll see you on Tuesday. Have a good weekend. We're adjourned.